Welcome to the ATV Community Podcast Series, meant to give Akwesasró a platform to discuss a variety of topics ranging from history, human interests, news, sports, features, and so much more. The views and opinions expressed in this podcast do not necessarily reflect those of Akwesasró TV or the St. Regis Mohawk tribe. Yawa for joining and enjoy listening in.
Sego, everybody. Welcome to Akwesasró TV's podcast of Akwesasró. My name is Darren Bonaparte, and I am the director of the Tribal Historic Preservation Office here at the St. Regis Mohawk tribe. And I've been interested in history for over 35 years now, and was involved with land claims starting in the 90s when I was a land claims researcher at MCA. And I have some special guests that I'm going to talk to about the current American land claim of Akwesasró. And I have some people who have a lot of knowledge, not only of the current claim, but of how the claim evolved over time. I'm very interested in hearing what they have to say. I'm sure a lot of people in the community are also very interested in it. And who I have with me are Jim Ransom and Dale White. Could you tell me a little bit about your background, both of you? Dale, starting with Dale.
Sure, Darren. My name is Dale White. I'm the general counsel for the St. Regis Mohawk tribe. I'm a tribal member, and I've been involved as general counsel and the land claims, both the settlement and the litigation, since 2006. I can bring some insights into some of the legal aspects of the settlement and the litigation because of my involvement. I've been involved in negotiations. I can't provide you detailed information on some of the confidential material, but I can give you an overview on the factual basis for some of the facts surrounding the litigation, some of the facts involving the settlement. Thank you.
Jim?
Yes, Sego Darren, and my name is Jim Ransom. I've been a lifelong community member, and I've been involved in the land claims on the southern portion of Akwesasró since 1999. And at that time, I did a research paper and worked with all three councils, and they provided me with the land claim settlement proposals that had been developed since 1988 to 1999. I became a land claim technician for the Mohawk Nation Council of Chiefs for 2 years, and then when I was elected tribal chief, I became the lead negotiator for the land claim settlement that was eventually reached in 2005.
Okay. Most people, when they think about the American land claim at Akwesasró, they think back to 1982 when the Band Council first went to court, and then followed a few years later by the tribe and the nation. But there were activities in this regard long before that. Do you know about that?
If you look at the history, it goes back to 1796 with the Seven Nations Treaty, and followed in 1797 by the U.S. Senate ratifying that treaty, and that really entrenched it in U.S. law. So I know people argue whether it's a valid treaty, but the bottom line is once the U.S. Senate ratified it, in the eyes of the United States, it's a valid treaty. But for the purposes of reaching a land claim settlement, from my perspective, it's really irrelevant. The reason I say that is that beginning in 1816 and for a period of 30 years to 1845, New York State illegally purchased Mohawk lands. And I believe it totals around, at the time, 10,000 acres. The reason that it was illegal is because it violated the Federal Trade and Non-Intercourse Act, which basically said you can only buy Indian land if the United States government approves it. That didn't happen. So that was the basis for the claim. And after that, the question becomes, what have we done to try to get that land back? So, and you can jump forward and you can see that it's been an ongoing challenge, and that the community has tried a few times to do that unsuccessfully. There's hurdles, one being we weren't allowed in federal court. And in 1938, the council at that time had to ask the federal government to make an application in court to get back 144 acres in Hogansburg. And the United States attempted to do that, but they lost the court case. So 144 acres was lost, and we can't relitigate that. From there, not associated with the mainland claim is Barnhart and Baxter Islands. And they're in the claim for different reasons. And in that case, it's because at the time of the 1796 treaty and its ratification, they weren't in American side of the border. They were on the Canadian side. And it wasn't until the Treaty of Ghent in 1814, after the War of 1812, and actually in 1822, there was a boundary survey done for the international border. And it relocated the islands, and no longer were they in Canadian waters, they were determined to be in American waters. And when they did that, we owned it. I should say the community owned it. And they were Mohawk Islands. Barnhart was leased to a guy named Barnhart. And so that action was taken, and that's how the lands left our community. There was an attempt, I believe, in 1954 to have a court case to return those islands. It was dismissed. And really, one of the things that happened that allowed a claim to go forward was 1974, when the Oneidas had a Supreme Court decision that allowed for compensation for losing Aboriginal lands. And following that, then you saw the Mohawk Council of Akwesasró file its claim in 82. The councils get together in 86, enter into the first tri-council resolution, and then ultimately the Mohawk Nation, Council of Chiefs, and the tribe filed their own lawsuit in 89. And I believe the judge enjoined all three because it was the same suit, basically. And all three became one land claim lawsuit.
So in that 1982 to 1989 submissions, the complaints to court, it's entirely speaking as representatives of the people of Akwesasró, right? Or the descendants of the St. Regis Indians that's mentioned in a treaty?
The two complaints that were filed in 1982, well, the one complaint was, people often think of this as the St. Regis Mohawk tribes, but it was the Mohawk Council that filed in 1982. And 7 years later, in 1989, and it's often referred to as a joint filing between the St. Regis Mohawk tribe and the Mohawk Council, Mohawk Nation Council of Chiefs. So you have, that was filed originally, and actually the people think that the land claim started in 1982. They didn't. They started back in the 1970s. It's just that a complaint wasn't filed. What happened was that the Cayuga Nation had filed, other eastern tribes had filed cases. The tribes in Maine were the first ones to initiate a land claim. Then the Cayugas filed, and the Oneidas, can't tell, I don't know exactly which one filed first, but the Cayugas did, and that attracted our attention at that point. So we hired Arthur Gayarsa, who is the attorney for the Cayugas, and said, why don't you look at our case? Why don't you see if we have a land claim? He came here, we hired him, and a lot of people don't know this, but the complaint was not filed until that time, but there was a lot of activity in the 1970s, and there was a proposal to settle in the 1970s, and it was rejected by the community. I guess it was too soon to settle. I don't know what the terms were at that point, but that's kind of the history of it. It's been going on a long time. So people say they use the 1982 date, but I would say it would go back to the mid 1970s. So it's 45 or 50 years of activity on the land claims litigation and settlement. The litigation has been going on ever since, and it's been stayed or paused while there's settlement. So for many long periods of time, if you look at the case, there's no activity because the parties were settling. The parties had settlements in all of the decades that the case has been around. In the 70s, 80s, 90s, 6 decades, every single decade there were settlement attempts, and for whatever reason or not, they were rejected or fell through.
It kind of stands out to me as curious about the late 1980s, considering the political climate of Akwesasró at the time, that the Mohawk Nation and the St. Regis Mohawk tribe would do something jointly, like a land claim like that. That was pretty very unified kind of thing for them, even though we all know they were sometimes at odds politically.
And the idea behind it is the 1796 treaty was, everybody knows that here, was with the St. Regis Indians. So the legal standing for bringing that case would be whoever is the successor to the St. Regis Indians who negotiated and signed that. So that would be the likely candidates would be the St. Regis Mohawk tribe, federally recognized tribe, MCA, even though they're located north of the border, or the nation. And so they all filed so that the case would not get dismissed because they didn't have the true successor to the St. Regis Indians.
Picking up on your comment, I find that very interesting as well. And if you consider that in 79, 80, we had the incident with the fence line on Racket Point that led to the encampment, there was great conflict between the traditional people in our community and the tribal people in our community. And that 2 years later, the councils, the tribal council, the Mohawk Nation Council, are in discussions about working together on land claims. And I think the reason for that is the individuals involved at that time. Mm-hmm. And Julius Cook had been elected tribal council chief, and he had a traditional background as a silversmith. He knew the culture, he knew the traditions. As a member of traditional person, he understood that perspective. And he was able to work with Leonard Garrow. I think it was Solomon Cook at the time. Yep. And, they were able to have a dialogue and conversations with Mohawk Council of Akwesasró, informally first, and then by 86 through that first resolution that said, we will work together. So, we've overcome our differences because we saw that a land claim settlement benefits the whole community.
It's interesting, Jim, because my father was a chief in the late 80s and early 90s, and he has I have pictures, I have photographs that he has over the years that shows there not only were the chiefs from the different councils involved in that, but they formed committees, land claims committees. So I have pictures and it involves both the nation and MCA and the tribe together sitting around a table, and then they actually show some maps. They have drawings, and they're very similar to what today is. The elements of the settlement being land, power, and some money and jurisdiction. So there's a long history of it. People don't tend to think that way. I've heard people say, well, why are you rushing into this settlement? Well, we're not rushing into the settlement. It's been going on for many, many decades. I think because of the long gap possibly between when the 2005 settlement was and today's settlement, a lot of people aren't aware of it. So yeah, that's one of the reasons why we're doing this podcast, because we want to let people. The tribe has done numerous things. We've had meetings, community meetings, some well attended, some less than well attended. The tribal chiefs did a video where they showed the elements of the settlement. We have FAQs that we put out. Now, while I have a chance, and before I forget it, there's a really good document that the tribe put together that answers, I think, what would be the most basic questions about what is in the settlement. I said earlier that we cannot divulge, we can't hand out the actual settlement documents because they're not all completed now, and that's not allowed under the rules. But if you look at the FAQs, it goes through each one. It has a map showing the lands in the land acquisition areas. It has terms of the settlement without actually revealing what the language is, but it accurately depicts exactly what is in it: the lands, the power, the tuition, and all the other benefits that we're getting from settlement.
Yeah, and if you look at, to pick up when your father was on council, that time period, again, 1990, we had the gambling wars in the community. Right. And we had tremendous division in the community. Again, MCA, the Mohawk Nation, the tribal council were not on the same page. And out of that came additional discussions on land claims. They overcame their differences and again became united in saying this will benefit the entire community. And it resulted by 1996 in they reaffirmed their relationship in that it would be a united claim, and did the second tri-council resolution that says that. So we've been tested collectively as a community. There's a lot of reasons not to do this land claim, but every time that's occurred, we found the reason to do it and have overcome our differences.
And one thing to add there, it's sometimes we look at this as the tribe and the nation and MCA as having complete control over this. We've had how many governors that have been New York State governors who've been dealing with this? Many of them, especially during the time period you're talking about, Jim, that haven't been very favorable or friendly to us. And early on, I think when we probably had the most leverage in order to settle, because we hadn't had the court cases that I think you're going to talk about in a minute, that basically led to dismissal of most of our claims in the litigation, the Sherrill case and the Cayuga case. Before that, we didn't have those. We had the 1940 decision that dismissed the 144 acres, and we had the 1950 ones, but I don't think the court really addressed that. But before that, we had kind of a clear landscape, a clean landscape, essentially, for being able to go forward with our case. But it was the federal government sometimes, and it was the state and the counties who were against it. And that happened with all of the nations in New York State who were seeking to get land claims. They had their U.S. representative in the Cayugas was adamantly opposed. He took the side of the non-Indians, and he prevented settlement of the Cayuga case back then. I don't know if we had anything that stark in our situation, but certainly there was a lot of opposition. We had some good settlements, I think, during that time that in retrospect, maybe we should have settled, but we didn't. But a lot of it was due to the hostility in Albany, hostility in our local communities, and hostility in Washington.
How did the Sherrill decision?
I was just going to say this was all pre-Sherrill.
Plan off the rails. How did that come about?
Well, I mean, Jim will probably jump in here, but what you're talking about is a settlement that was started in 2002 or 2003, and then was rejected, and then went to a full referendum, and then was approved, and was very, very near. It had gone to Albany. It was signed by all of the nations and the tribes and the council, Akwesasró Mohawk Council, and then it went to Albany. While it was being approved in Albany, the Sherrill case was argued, and the Sherrill case was decided. In the Sherrill case, I won't go into a lot of detail, but it basically said that the doctrine of laches applies. And all of the attorneys who worked on the Eastern land claims cases before then, I talked to them, were very worried about that the longer you take, it's almost like a statute of limitations, but what it is, it gives the court discretion to dismiss cases that the parties have known about but they say that sat on their hands and did not bring until a long period of time, which is ridiculous regarding our tribe and any of the tribes who brought these cases, because they relied on the United States. They didn't have, we didn't have legal counsel. The Supreme Court had not even decided that the non-intercourse could apply to our claims until 1974 in the Supreme Court, the Oneida case, where it said you can have a cause of action, and then later affirmed the remedy in 1983 in another, it's Oneida 2, that was argued. So the Supreme Court in the Sherrill case, it was not a land claims case technically. It involved the Oneida Nation acquiring property within their historic reservation, and they asserted sovereignty over it. The court said that you've waited, I don't know, 100 years or 150 years to do that, and we're not going to allow that to happen. It was a Justice Ginsburg decision of all people, a liberal justice. and so that case went down, and then you can talk about the after effect of that with the Cayuga Nation.
Yeah, and at that time, the timing couldn't have been any worse for us in that we signed our land claim settlement with the state of New York in February of 2005. The Sherrill court decision came out, I think, 2 months later. And so we've been feeling the impacts of that court decision ever since. And even with that court decision, our land claim settlement stayed alive initially. The counties stayed on board, the state stayed on board, and it wasn't until after the Cayuga decision, and the Cayuga decision was 2 months after the Sherrill court decision. And what the court decided, it relied on Sherrill, and Cayuga was much more clearly the Latches decision. And they said that because you haven't lived in this area so long, that the non-natives have lived here, and it would be too disruptive to allow your claim to go forward on those people.
They had an expectation, and then this was disruptive. It was
Yeah.
a made-up Supreme Court decision.
You know, and then from that point forward, everybody else lost their court claims, their land claims. The Onondagas, Oneidas, Cayugas, and us. People don't realize that. It took long for us. 2012?
Right.
In 2012, the magistrate made a decision that our land claim could no longer survive in court except for the Hogansburg Triangle. And the reason that that was allowed is, if you look at Latches, it says basically that the character of the people on the land changes and that it's gone to a non-native character. Ours was just the opposite.
Jim,
Yes.
can you be able to move closer to your
Okay.
microphone?
Ours was just the opposite. So we've been buying our land back for many years. And in Hogansburg, I would say that at that time, 95% of the land had been repurchased by our community members. So the character of the land was an Indian character, not a non-Indian character. And so the judge in 2012 agreed with that position and said, we cannot use Latches against this part of your claim. And it survived. So the court case is only about the Hogansburg Triangle now. We've lost everything else, same as the Oneidas, Onondaga, Cayugas. You know, that's the challenge that we have in the court case. The settlement provides a pathway to have the lands reacquired and put back under Mohawk ownership and Mohawk jurisdiction. That's the value in going forward.
That's awesome. What if worst case scenario, everything falls apart, case is dismissed, it just collapses. What happens to those people that bought land
That
in the Hogansburg Triangle?
Well, that's something that I don't think has been emphasized enough, is that we have documentation of tribal members who live in those areas. The areas are called, there's an attachment to the settlement. There's Area A, which is Hogansburg Triangle. You have about 95% of Mohawks live there. I've never counted, but there's over 50 landowners in Hogansburg. They would automatically, their lands would automatically become, once they convey it to the tribe and get a right to use and occupancy, that would become reservation status. East of that is an area called Area B, which is the 7,000 acre area. And you have an area, Zone 1. There are many tribal members who own lands in that area. So and I can go through the other two areas as well, areas C and D, which are in St. Lawrence County. If we do not settle, there are people now who will be directly affected by that because they have land that they're paying taxes on or they're foreclosed on in those areas. And that if we don't settle, they really don't have a remedy unless they're living in Hogansburg. And we don't know what that remedy is going to be in Hogansburg. We're going to argue that we get title back in Hogansburg. You have to wipe out all the taxes that were illegally assessed in Hogansburg, or we get money damages for that. We're not going to get title back on those properties. We'll have to resort to taking those lands into trust.
There is a plan B, and people don't talk about it, and I think some people don't want to talk about it. And that's that the tribe has the ability under current U.S. federal law to take land into trust. And that avenue will be open if everything fell apart. And the tribe has already done that and took the 39 acres where the transfer station into trust 2012.
Yes. One aspect of the settlement is the $70 million that we're getting from NIPA, and maybe we should address that because there are voices out in the community who are criticizing the settlement. I've heard that we're selling our land and that all we're getting is 70 million acres. Well, that's wrong. The 70 million, and Jim, you can confirm this. The $70 million that we're getting was also in the 2005 settlement. And that's not buying land. That is getting compensation from NIPA for under the FERC license. It would have gotten under the FERC license that was approved. And we also received some other natural resources damage from that. It wasn't the only thing we received. But in no way, shape, or form are we selling land or are we getting money for it. It's the paramount thing for, I think I can speak for council, is the land. The generations of people who now don't have land, the people who own land and their land will be converted to reservation status, and the people who will be able to acquire land. Especially, I look at those parcels in C and D in St. Lawrence County. We've really never owned land in St. Lawrence County. It's all been in Franklin County. And you have people who have bought along those roads and with the expectation that there's going to be a settlement. And I think we owe it to those tribal members. We had 3 meetings. We had meetings with the business people, we had meetings with the landowners, and we had just a general meeting in this very room to explain the settlement. Many people came in who were in the category of, I own land and I want to see this go through, and there's a number of them. I could look at my FAQs right now, but it lists the amount of acreage that will immediately become reservation land. I think it's 3,500 acres that the minute that this thing is signed, the minute that the conveyances are made, we don't have to buy land in the future. It immediately adds to the reservation. You open up these huge areas. C and D are outside the 1796 reservation boundaries. So we're doubling the size of our reservation. And people can criticize it. We're not getting the 9 million acres that some people, I think, believe that we're entitled to, but that's not what this case is about.
Well, we don't have time to delve into addressing all the complaints that are out there. That we'd be here all day. But you gentlemen have given me a lot of information. I'm a little overwhelmed by the level of information. and things that I'd always wondered about, the insights into how it all evolved over time. I always wondered about what, the people involved. And in talking to you guys before we got on camera, some of the colleagues that you've had that have passed away since all of this began.
Yeah,
and when you
my
were
father.
mentioning the names, your father,
All right.
like Mark Narcissian and Sally Benedict and
Barbara Barnes, Barbara Gray, Brian Skidders, Jake Swamp. I had the privilege of working with all of them. And so the settlement that's on the table right now is a product of all of these people. And, I've got in my records every meeting that took place, every negotiation session with the state of New York, and it includes who was there, what they talked about, when it occurred. And it was all these people.
Yep. When I started working here in 2006, there was no settlement because of the Cheryl case, and that lasted for probably another 7 years. One thing that people need to understand is that there was no reason why the counties or the state at that point should have reopened negotiations. We were in court, and they had the Cheryl case behind them, and at that point in 2013, the court had dismissed all of our claims except for Hogansburg Triangle. What we did at that point was pretty miraculous, I think. We leveraged the revenue share revenue. We withheld $60 million, and we went to the governor and we said that we're going to hold this until you do X, Y, and Z. And we had a number of issues that we wanted. It was Governor Cuomo that we needed to be addressed. One of those was to get back to the settlement table. We were able to get back to the settlement table, and the settlement that we have now is virtually identical to the settlement we had prior to in 2005. There are a couple of exceptions. So we were dead because of Cheryl and because of the tribal councils at the time and the efforts and the leverage we used. We resurrected a settlement that I think was nearly miraculous to resurrect. People don't understand that. They talk about how, the settlement is terrible, we should do this and that, but it's almost better than the settlement that was approved by referendum. In some ways, it is better.
Jim, do you have any final thoughts?
I have a whole bunch of final thoughts, but one of the things that you have to look at in terms of the impact of Cheryl and Cayuga is that in the 2005 settlement, it was $100 million, not $70 million. After Cheryl and Cayuga, and to pick up on what Dale said earlier, the $70 million from NYPA is not for the land claim. It's for the NYPA relicensing of the hydroelectric project. They got relicensed in 2003, and we were participating in that relicensing. But when the council at that time did their memorandum of understanding, they lumped the NYPA money in with the land claim money. And so that's what ballooned it up to $100 million. But when Cheryl came out came the $30 million that was meant as compensation in the land claim settlement. So that's what reduced it down to $70 million. And the $70 million is from NYPA, as I think it's still part of the relicensing amount. So I think that's an important
I think that's
distinction to make in terms of how things relate to each other.
Let me just add one more thought, is that I think this is a two-purpose meeting. One is to get information out about the settlement, and the other is to address some of the criticism in the community. One of those is that there have been a number of people talking, people getting up at the meetings and speaking, condemning the settlement on any number of reasons, but no one has thus far indicated what their solution would be. We have a solution. Is it perfect? No, it's not perfect. We're not getting back all of our lands. because of all the court cases that have happened, because of the time that's gone by, and especially the Cheryl case, we're not going to get a perfect settlement. We may not have, even from the beginning. But it is a settlement, and it gets land back. But a lot of people are criticizing, but they're not offering what else we should be doing. And in terms of this idea that there's secrecy and non-transparency, the nation and has been involved, and Mohawk Council has been involved, and tribal members, and we mentioned all the people involved in this for 40 some odd years. It's been constantly discussed, many meetings. I don't know if, Jim, if you're going to do a chronology, if you could put together all the meetings that have been held on this and all the memos that have gone out, all of the information sessions that have been gone out. It's one of the things, I think, in the community that people should know most of all.
Yeah, and I just want to echo that. And if you look and see from 1988 to 2002, the state imposed confidentiality provisions on the negotiation and didn't want us the councils to talk to the community about the settlement. And in 2003, when the MOU came out, the full settlement was shared with the community, but there was no education of the community that went with it. It was take it or leave it, and they left it. When I got elected and the council that I was working with, we decided that we needed to educate the community on the land claim. It was missing, and it wasn't the council's fault, it was the state's fault. So we were up front. We told the state, we can't settle this without telling our community. And so we launched an education campaign in the fall of 2003 and into late fall and into 2004. We hired 18 community educators. We trained them and taught them about what's in the land claim settlement so that they could go to community members and share that information with them and ask them what their questions were, record it and bring it back to us, get their comments. At the same time that they did the education, they did a survey and asked a list of questions related to the land claim settlement. I think it was 1,775 people responded. And the education campaign, the educators, it turned out when we put the request for educators, because we hired them, who responded? Teachers. We were surprised. And who better to educate the community than teachers? And most of them were fluent Mohawk speakers. So they could speak with the community in Mohawk, and so collectively that engagement was, I think it had to be one of the biggest community consultations in the history of Akwesasró. The first time it had ever been done on both the northern and southern portion over a subject matter where the people hired were representing the whole community. And so it gave us the information when we returned back to negotiations with the state. We could then say, this isn't just our perspective. We asked our community. This is coming from them. This is what's important to them. And it changed the mindset of the state. And collectively, between the work of the land claim technicians, the community educators, and the council, that's how we got to the community the land claim settlement in September of 2004, had the referendum in November. And when we did the referendum, we did an exit poll that night. And people were called up, asked, did you vote? If you voted, how did you vote? And when did you decide to vote? And we were surprised, and we found out that a lot of people had decided how they were going to vote 2 months before the referendum. And I believe it was because the education process worked. People were much more knowledgeable. They understood what the issues were with the land claim and agreed with it. You know, the problem that we have today is my last point I'll make. The problem that we have today is that occurred 20 years ago. We've pointed out that a lot of the key individuals have passed away, and we've lost the institutional memory of what occurred. We have a new generation that in 2004, 2005, if you were born in 1995 to 2005, you were a child at that time. So you didn't participate, you weren't educated. In the last 20 years, we've lost that knowledge. The new generation has concerns, and they see things differently. That's okay, but it places a responsibility on us to re-educate, educate new people, share the same information, and rebuild a consensus on the settlement of the land claims.
This is our last chance for settlement. After 42 years of being in court, after everything that the parties have gone through, after having resurrected the settlement, starting in 2013, given the posture of the litigation and what we heard in court. We were in court at the end of February before the magistrate.
I don't agree. I am an eternal eternal optimist, and my perspective is a little bit different. I think that this is the best opportunity.
I know that one of the items that we need to discuss in terms of coverage of what's in the settlement would be the other things besides land acquisition, and that would be free tuition from all Mohawks in north and south of the border to SUNY schools. There are some 63 SUNY schools, and I think we've also gotten them to include community colleges. So that is free tuition. It's not the Excelsior program where you have to apply and you have to use it as a last resort. Free tuition. We get preference power, 9 megawatts of power that I would imagine would greatly reduce the electric bills to community members. That we would get preference. We would have to acquire that, but at a preference rate that's much less than we have now. The islands are something that is a little different because in the 2005 settlement, we were going to acquire the islands. This time we have access to it. And actually one of the islands is no longer available, I believe, so during that time period. But overall, the settlement includes those as well, but like I said, the thing is land. The power and the tuition is great, but land is forever.
On that happy note, we're going to wrap it up. I want to thank Dale for coming in and as a tribal lawyer. He's on the job now doing that. And Jim, of course, having quite a long duration as a community leader here in Akwesasró, to give those insights into the land claim. A lot of things that I didn't know, things that I might have forgotten over the years. This has been really informative. I want to thank both of you for spending the time to talk.
It's been a pleasure.
Yeah. So
thank you.
On behalf of Akwesasró TV, this has been the Akwesasró podcast. Yawakoa. Tanaona.
The views and opinions expressed in this podcast do not necessarily reflect those of Akwesasró TV or the St. Regis Mohawk tribe. Yawa for joining.